Judgment in the matter of Brake and another against Chedington Court Estate Limited.
Lord Richards will also explain this decision of the court.
The judgment in this appeal was handed down in August this year during the court's recess. The issue on the appeal was whether a bankrupt individual has standing under the Insolvency Act 1986 to challenge transactions entered into by the trustee in bankruptcy, where the relief sought would have no impact on the position of the bankrupt within the bankruptcy. Mr. and Mrs. Brake were made bankrupt in 2015. A partnership in which they had been 2 out of the 3 partners went into liquidation in 2017. In December 2018, the liquidator of the partnership agreed a sale of a property which was a partnership asset. The property, however, remained registered in the names of Mr. and Mrs. Brake and of the other partner. In January 2019, the trustee in bankruptcy of Mr. and Mrs. Brake agreed to participate in an arrangement to facilitate the transfer of the legal title to the property in consideration of payments to the bankruptcy estates of Mr. and Mrs. Brake and to the trustee's firm. Mr. and Mrs. Brake issued an application to challenge the actions of the trustee in participating in these arrangements, which they alleged amounted to a breach of the trustee's duties and which they said deprived them of the opportunity of acquiring the property. The application was made under Section 303 of the Insolvency Act 1986. The application sought orders setting aside the sale of the property to the appellant company, Chedington Court Estate Limited, which I will call Chedington. Chedington applied to strike out the proceedings on the grounds that as there was no prospect of a surplus of assets in the bankruptcies, Mr. and Mrs. Brake had no standing to bring the application under Section 303. The judge at first instance acceded to this application, but the Court of Appeal reversed the decision. For the reasons given in the judgment handed down in August, the Court allowed Chedington's appeal. On a consideration of the authorities and the purpose of the relevant provisions of the Insolvency Act, the Court held that standing to make an application under Section 303 is limited to, first, creditors applying in respect of conduct which is adverse to their interests as creditors, 2, bankrupts, but only where there is a real prospect of a surplus in the bankruptcy, and 3, a small category of cases in which the application is made by a person whose rights or interests arise specifically from the bankruptcy itself, rather than from some outside interest. The Court held that the application by Mr. and Mrs. Brake did not come within any of those categories. Accordingly, it fell to be struck out, and the Court allowed the appeal.
The Court is now adjourned.